We have to share some new developments in the hot car death case for defendant Christopher Scholtes. Should there be a second chance at a plea deal for this dad? You might remember he was the Arizona father charged with first-degree murder for leaving his 2-year-old daughter, Parker, in a hot car.
Oh my God. I don't want to feel like we're intruding, but we're going to have to stand by with you for a while. All right.
Is there a reason why?
So any death we have to treat like a crime scene. I know this is extremely difficult for you. This is a normal process that we have to follow through with. I don't want you to be blindsided by anything, but that's what's going to be going on for right now, okay?
So I'm being treated like a murderer?
No.
I just lost my baby.
No. I know that.
Now, he already rejected one plea offer to second-degree murder. He wants to try for a new deal, though, with the state. His defense attorney says he's developing some new evidence that would substantiate the argument for a reduced punishment for him. Well, this morning we've got some unaired footage from his court appearance last week. Before we get to that, let's get you the background of this case. Reporter Craig Smith from the Scripps News affiliate in Arizona has more.
Marana police say the 2-year-old girl died after the father left her in the backseat of the family car for more than 3 hours. The man told police that he left the engine and the air conditioner running, but he also knew that that car would shut itself off fairly quickly. The young girl died on July 9th. Marana police originally said Christopher Scholtes left the 2-year-old girl in this car with the air conditioning running, but the air conditioning shut off. He said he had left the child in the car before and did not want to wake her because she was sleeping. This is one of her own company cars, but it has a feature the car in this case had too. If you put this car in park and leave the motor running, the car will shut off automatically in 30 minutes. And police say Christopher Scholtes knew that. According to the interim complaint, the family's other children, aged 5 and 9, told police Scholtes often left all the children in the car, and on this day was distracted by a video game and by putting some food away. Scholtes' wife is a medical doctor. Investigators say she came home about 4 p.m. and asked where the 2-year-old was. The report says Scholtes searched through the house, then remembered the girl was still in the car. By that time, the car and its air conditioning had stopped. Police say by late afternoon, the temperature was 109. Scholtes told police he had returned home with the girl by about 2:30. Police found neighborhood surveillance video that showed they'd returned at 12:52, about 2 hours sooner. The child's mother tried to revive the child but could not. Police say as an ambulance rushed the child to a hospital, the mother texted Christopher Scholtes, "I told you to stop leaving them in the car. How many times have I told you?" Scholtes responded, "Baby, I'm sorry." The mother texted, "We've lost her. She was perfect." Scholtes said, "Babe, our family, how could I do this? I killed our baby. This can't be real." A second-degree murder charge is applied if someone dies after a suspect has taken actions indifferent or reckless to human life. If found guilty of second-degree murder, Christopher Scholtes could face between 25 years and life in prison. Craig Smith, KGUN 9.
Oh, how dreadful. Now, Mr. Scholtes was in court on Friday talking about that plea deal. This is some unaired footage. Let's go into that Arizona courtroom together.
25 Curtis, please announce.
Good morning, Your Honor. Haley Weingold and Brad Terrace from the state.
Good morning, Your Honor. Mark Adair, Assistant Law. On behalf of Christopher Scholtes, President of the
We are set for a 7 trial date, and then yesterday I did receive a pre-trial services report noting concerns about possible violation of release conditions. Why don't we address the trial date first?
They just ready to proceed with the October 27th trial date. It's really that they have already to proceed, ready to go on that date.
Okay. Are plea negotiations ongoing?
No, the plea was previously rejected and withdrawn, so it is just a trial.
Okay, thank you. And Mr. Darrigan?
Yes, Judge. In terms of the defense, I would notify this court, I've already notified the state, that I will be filing a motion to continue the trial date for a number of reasons. I know our motion deadline is not due for a while, but I'll have that filed next week to address those issues. I think it's going to take motion, and I'm prepared to put it all together. In terms of your question whether negotiations are ongoing, this is one of the issues that I have had, and I've also raised this with the state, is that the defense would like to be able to participate in a settlement conference. Given the nature of this case, given the nature of the charges, I understand that it might pose some difficulty in the sense that usually at a settlement conference, parties that can settle the case have to be there. Anything having to do with the resolution of this type of a case, again, this type of a charge, would require approval through the panel. This case went to the panel very early on after it was charged, and the defense did put together mitigation that I know was considered by the state and the panel, but it was very early on in the case. Since that time, Judge, the defense has retained a mitigation specialist, and we've been working diligently to try to get mitigation evidence put together, specifically as it pertains to these kinds of cases, specifically deaths for children left in hot cars. So we've been doing research across the entire country in that regard. We're still trying to put that together. But I've received or heard back from the state that there is at least a willingness to listen to any new mitigation, and I'm suggesting that there is a lot of new mitigation because of the passage of time and being able to work on that with the mitigation specialists that we were not able to do in the time that we had to have that submitted to the panel. So I've not heard directly from the state that they would be unwilling, but that's something, again, that the defense would be interested in pursuing. I believe we are close, but probably still several weeks before I have a mitigation report. But that is something that the defense would like to participate in. Those are the two issues I heard the court bring up, and I'm certainly prepared to address the pretrial services report as well.
Okay, so Mr. Chair, are you requesting that the court order a settlement conference?
I forgive my ignorance. I'm not exactly sure how it works down here in Pima County, but if it's something that's going to require, I thought we would disagree on a date, but if that's the way I have to do it, then that's the request I make. I don't know if that needs to be in writing or not.
It does not have to be in writing.
Okay.
Okay, and Ms. Weidel, what's the state's position on requesting a settlement conference?
At this point, it would be fruitless of anything. The plea is not changing. The panel has extensive information. There has been, plenty of time for additional information to come in the sense that if defense provides mitigation material, we'll hear them out on mitigation, we'll review that if it's provided to us, but it doesn't mean we would repanel or the plea would change in any way. He had an opportunity with the plea from the panel that was open for a while. And negotiations were open. That was the plea. He rejected it. I really don't see how it will change any circumstances and really be productive in any way. So we would be objecting to a settlement conference.
Okay, thank you. Did the parties receive the status update dated August 14th, 2025 regarding information reportedly from a representative of DCS?
Yes.
Okay, may I have the state's position?
So to clarify on that, I was able to speak to the DCS caseworker that was there and observed. The defendant's wife was in the car outside, parked outside. He came in by himself to sign the kids out of school. She was in the car outside. The concern was not knowing if there was anyone else with him, a violation of his conditions of release, no unsupervised contact with minors. The DCS caseworker happened to be at the school that day and at that time. We learned yesterday there's an open DCS case in Phoenix, like the base in Phoenix, based on allegations and a report made by the defendant's 17-year-old daughter. Because of that, there is an open case. It's been open for a couple months. And the information that the state has is that there was trouble figuring out where the defendant and the children lived, and contact because they need to do safety checks and interviews with the other 2 kids that are in the home. So that DCS case was opened unrelated to this, but it's still an open DCS case that the defendant has pending, and that there's some struggle with cooperation. We also found out that he is now living in Phoenix. That was new information to the state. One of the things we were going to inquire if pretrial services was here, and what we would still like to know is whether or not he notified pretrial services that he moved out of the county, what, and an address and contact information. As a condition of his release, he has to notify the court immediately upon changing an address. So that was new information. We're unsure whether or not he did let pretrial services know that he had moved or not, and that he was now in a different county. On the 404 mention, the state actually is anticipating filing a 404 motion this afternoon. So we would also ask today while we're here if we could set a hearing date, since all the parties are here, for that 404 hearing. But we intend to file that later this afternoon and provide the materials to the court.
So you're intending to file a 404 notice?
Notice and motion together.
Okay. And then, Mr. Dare, could you address the concerns from the pretrial services?
We're going to hit pause right there. So will this defendant dad get a second chance for a plea deal? Remember, he's charged with first-degree murder, so that means life imprisonment if he's convicted. They reduced it to second degree and made him an offer. That would be anywhere from 10 years to 25 years imprisonment. He rejected that, but as you can see, they're trying to work on something else. In the case of this victim, that is 2-year-old Parker Scholtes, who should be alive today. Look at this beautiful child. She's what this case is about. We'll watch more of that hearing live together next.
I can't believe this. This can't be happening.
Matriarch of the Adelson family gets arrested.
Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins this week, only on Court TV.
She was sleeping in her car, and I had the car on, but it has a sensor where every 30 minutes or so it'll turn off if you haven't moved. I swore she was in the house playing with her sisters like she always does.
Welcome back to Court TV Live. I'm Julie Grant. We are watching the latest hearing from that Arizona hot car death case involving defendant Christopher Scholtes. He's accused of first-degree murder for leaving his beautiful 2-year-old daughter Parker in a hot car in their driveway in sweltering heat. Now, he was offered one plea agreement where prosecutors offered to amend that first-degree murder charge, which would carry up to life imprisonment as a penalty, to second-degree murder. And then the penalties become much less. They go anywhere from a mandatory minimum of 10 years to a max of 25 years. Well, he rejected that. And now we're hearing his defense attorneys saying they're still looking to deal. They're still looking to work this case out with some new information that they're working on. So let's go back in where we left off.
His wife was present.
I received a call from my client yesterday advising me that DCS was at the school, so it certainly begged the question, why was DCS at the school in Maricopa County to where Mr. Scholtes and his wife have moved, frankly, to escape the specter of this trial and the allegations and the media attention on the case. But with respect to notifying pretrial services, they were fully aware that my client and his wife and family had moved out of Pima County to Maricopa County. The idea about struggling with cooperation, I think that it's a huge stretch for the state to say that the open case has to do with his 17-year-old daughter when that information has been a big part and parcel of this case here. And it was always something that the defense was anticipating. A 404B motion would ultimately get filed in this case. In anticipation of that, the defense requested records from DCS involving Christopher Scholtes and his daughter, to which they've not responded. I believe now with this newest allegation and now knowing a little bit more about it, that I'm going to probably have to seek court assistance in getting those records. I don't know if what the state's going to provide in support of the 404 is going to cover everything, but I would like the court to know that Mr. Scholtes' parental rights were totally severed with this person that's making the claims for what is cause an open investigation to occur. There is no obligation on his part, financially, visitation-wise. I can't even anticipate what kind of allegation is being made now that apparently was made months ago. But that is another reason why I would be including in my motion to continue, is because now this issue has come up. But yesterday, the way this report is written, Your Honor, I mean, when he came to check out his children, because it was his wife's birthday, by the way, yesterday, and they were going out for a birthday lunch. His wife did accompany him to the school. When he went to actually physically check out his daughters from the school, he was accompanied by school faculty. He was never by himself. We recognize and understand that he has not to have any unsupervised contact with minors, but that clearly was not the case yesterday.
So I hope you agree that Mr. Scholtes was in compliance with his release conditions.
Yes, sir, but the concern was before they knew that anyone else was with him outside, that he would be taking the kids alone. But I'm confirming myself with the DCS caseworkers that his wife was present.
Okay. All right, so I'm going to consider that issue settled.
Thank you, Judge.
Can you inform the court when pretrial services was notified of the move to Maricopa County? And the manner of notification?
I'm being advised by my client that he had a phone call with Stephen Carlson, who is his assigned PTS officer, and that was in May.
Thank you.
And the actual move wasn't until 6 weeks ago.
Okay. All right, so on the defense or motion, the court will order a settlement conference. Will be over the state's objection. And Ms. Weigel has set a hearing date that works with your schedules related to the 404 motion and any motion to continue the trial that the defense will file. My long motion day is Friday afternoon. I have Friday, September 19th available.
That would work for the defense, Your Honor.
For the state.
The 19th, sure.
Okay. Shall we say 2 o'clock for 60 minutes?
That sounds perfect, Judge.
Right, so I'm going to order hearing date for September 19th at 2 o'clock. That will be for 60 minutes before Division 28. This will be for the anticipated 404 motion filed by the state and an anticipated motion to continue trial filed by the defense. And Ms. Weigel, is there anything else on behalf of the state today?
No, Your Honor.
for the defense?
Nothing for the defense, Your Honor.
All right, I'll also go ahead and set a status conference regarding trial date as well on the 19th, just to track that. There is a deadline for a questionnaire for July 20th, I'm sorry,
The 18th? No.
I'm showing September 22nd.
Yes.
It's about 30 days before the trial date. I do want a questionnaire in the case, so we'll send one out for the parties to review. I want to keep that timely in the event that the trial does proceed as scheduled, so that parties have enough time to have their input. So do expect to receive that by email. Is there anything else at all? Okay. All right, thank you.
All right, so the parties are going to have about a month to try to work things out. September 19th, they'll be back in court, and we'll see if they're able to arrive at an agreement to dispose of this case without a trial. Let me bring in now our legal analyst guest to talk about what might be an appropriate deal for Christopher Scholtes. Attorney Jessica Mashali is with us, practices criminal defense in the state of Florida. We saw her in action in one of the trials that we broadcasted here on Court TV. Jessica, great to have you back on the show. And tell me, as you're watching this hearing and thinking like the criminal defense attorney that you are, what do you think would be a fair and appropriate ask for your client if you were representing Christopher Scholtes?
You know, it's a tough case, Julie. You know that I have young kids, and even just watching today is difficult. It's hard to listen to, it's hard to hear. I had a case like this about 10 years ago, a hot car, a death of a child, and it was very, very, very difficult. I think it's clear this father did not mean to hurt his child, but the evidence shows that he knew what he was doing. I mean, you live in Arizona. You know what the temperatures are. He had been told not to leave her in the car before. This is just a horrifying, horrifying thing that happened. I think an appropriate sentence for him would be 10 years in prison. I'm sure that he thinks he should not have any incarceration.
Mm-hmm. You think that's where they're stuck, huh? On the fact that the state probably thinks time is appropriate for him. And I'm with you, Jessica. I think he's got to do some time, has to do some time. Perhaps something lesser than life. I can understand where his defense team was going, whoa, we want to get off this first-degree murder charge, get away from that potential penalty and get in the vicinity of something more like second degree where it's 10 to 25. Tell me, do you think they're going to be able to arrive at something based on what you heard today? Do you think that there can be some kind of a meeting in the middle here?
I think there definitely can, because any case can be settled where the people are working together. I always think that cases where I don't have an offer to settle from the state is just kind of a crazy situation. There should always be some kind of settlement. I think that this guy probably thinks that he shouldn't have any repercussions whatsoever. And he's going to have to come off of that a little bit if he doesn't want to risk going to a jury. And honestly, I don't think I would risk that in this case.
Mm-hmm. Right, too risky. Yeah, I mean, you see that beautiful face. Oh my gosh, that little Parker, what a gorgeous child. Had her whole life ahead of her, like her mother said in those messages we saw earlier from the reporting done by our Scripps News affiliate in Arizona, how the mother said she was perfect and now we've lost her. She was a perfect child. And Dad knew that this was a problem with him. He knew that this had happened before. He was warned, don't do this, but distracted, whatever he was doing, playing video games, and now this little angel is dead. So you're right, Jessica, going in front of a jury, I can't think a lot of people would have sympathy for him. Tell me, if you're the prosecution, do me a favor for just this moment, be a prosecutor for me, my friend. Tell me, what do you think would be a fair offer to extend to this guy, knowing that, look, he suffered a loss that, I mean, is an irreplaceable loss. His own child, through his conduct, we're acknowledging, and I think the defense is acknowledging, they want to work this out. What do you think would be a fair offer to extend to the defense?
So, Julie, like you said, you're spot on. The natural consequence of his actions is worse than any punishment he could ever receive. The fact that he no longer has his child and that he knows that that's his fault. the fact that he was playing video games and not like in some other cases we've seen like this where the person is seriously overwhelmed and there are other things that are important that are going on and that's why they forgot. This is sort of, he intentionally left her there. He knows what the degrees are outside. He knows the car's going to turn off. He's in the house playing video games. It's really inexcusable. And so I think that while in some cases it's more understandable. In the case I had, there was in fact no prison time in the sentence. But here, I don't think that that would be appropriate, and I don't think he's going to get that offer from the state. I do think that this was accidental and that he is suffering and that he is not really a danger to anybody else. And I think that the state should offer, I think that second degree would be appropriate as the highest charge, maybe even a lower charge than that. And I think that they should offer something between 10 and 15.
Jessica, I'm in agreement with you. I think that would be very, very fair. Agree on a firm term of imprisonment, put him on an extended period of probation after that, keep him monitored, keep him accountable. I think a guy like this needs some parenting classes and some things, that could help him when he goes to, to finish his term and get back into his home life. But I'm with you. I can see why they're a bit stuck because this is such a bad loss. Where do you go from there? How can you make him suffer more? I don't think you possibly can. Jessica, really appreciate your insight. Again, September 19th, Christopher Scholtes will be back in court, and we'll see if we have a deal. We're remembering precious little Parker, the victim in this case.